This is Rob Norman, counsel for Pike off OTA and a nice number of homeowners in our district court case, in our Supreme Court protest, various other matters. Here to kind of update you on some of the things that are going on with some of the cases. Obviously, you've been hearing a lot about the Open Meetings Act case. That's hot and heavy. But I'm going to kind of give you some lowdown on what else is going on. First, the Supreme Court case. As many of you know, and many of you tuned in, and many of you were there live, and we appreciate that. That was great. The Supreme Court case, we are awaiting a Supreme Court ruling on basically what we feel is the legality, or what we contend is the illegality, of the new turnpike routes in Access, Oklahoma. We have submitted briefs, we have done oral argument, and the Supreme Court is just going to make a decision at some point about what they're going to do with that case. A big question everyone asks is, when is the Supreme Court going to make a decision? Well, we don't know exactly when they're going to make a decision, and we have to just live with the fact that they rule on their own time and they don't have a deadline. But keep in mind that with this statute, in an OTA bond approval case, what the Supreme Court kind of does is they take that case from the bottom of the stack and put it on the top of the stack. So we feel and we're confident that they're moving diligently and that they will not unduly delay this case, and that they'll get their work done. They have to go around, they have to decide, who's going to write the opinion, how are we all voting in different ways, what exactly are we going to rule. It may not be just a case of win, lose, or draw, simple thumbs up, thumbs down. They've got to consider things like, okay, if we rule in favor of one side or another, how do we send this back, and how do we give people guidance on how to deal with our ruling? If you were at the Supreme Court hearing, you heard a lot of questions from the Supreme Court about that. How do we sever out, if we rule in favor of striking down the new turnpikes, how do we sever that out from the rest of Access, Oklahoma? Does this have any effect on the Kickapoo? So those are things that the Supreme Court has got to think their way through, and not just deciding who's right or wrong about this. They've got to think that sort of thing through, but I'm confident they're moving diligently and that we're going to get an expeditious ruling from the Supreme Court. So there's nothing we can do about that but wait. We feel good about the case. We felt good about oral argument. We felt good about briefs. You never want to take too much away from what you hear from the Supreme Court in oral argument, but that went about as well as we could expect. And that's just a matter where there's no hard deadline on the Supreme Court, but we think they are kind of tasked with deciding it promptly, and we think and hope they will. So that's kind of the Supreme Court case. We're feeling pretty good about it. We're just awaiting on a decision. Now the rest of the matters. The district court case that we have to deal with, Pike off OTA, that's still going. We plan on appealing the recent district court ruling in that case, but that's not a ruling on the merits. We've gotten a lot of questions about that, about what that means. All the district court judge really did in that case was decide that the Supreme Court gets to decide the issues rather than the district judge on the legality of the routes. So it's okay. Don't get too worried or overthink your way around that. We're still going to get a ruling on the merits from the Supreme Court either way. Now, about the rest of the things, some of the questions have come down. What happens if we win? What happens if we lose? Things like that. Well, I think quite simply, if we prevail on the merits in front of the Supreme Court, it's kind of done for the OTA in front of the Council of Bond Oversight, or in front of the district court in our lawsuit on the legal challenges in the district court. That's a ruling on the merits in our favor. People have asked kind of to clarify what went on at the Bond Council and how does it have an effect today. Well, let's remember the Bond Council basically said that for the OTA to issue bonds for these 3 new turnpikes, they have to prevail 3 times. They have to prevail in front of the Supreme Court. They have to prevail in the Open Meetings Act case. And they have to prevail in the Pike District Court case. None of those cases have been decided fully and finally, but I can tell you that none of that's been decided fully and finally in front of the OTA. So there are 3 dominoes that the OTA has to knock down to be able to issue bonds and move forward in these turnpikes. We feel obviously we've gotten a favorable ruling in the Open Meetings Act case. We feel like we're doing well on the merits in the rest of the cases. So it's a long ways to go, but things are going well for us in not letting the OTA knock down those 3 dominoes and us being able to ultimately prevail, keep those dominoes up, and not let the OTA build these 3 new turnpikes. So then what would the OTA do and what would we do? Well, probably we win on the merits in front of the Supreme Court, and then probably the case goes to the legislature. The OTA may very well go to the legislature and try to get those routes authorized. I can assure you that the Pike group and the citizens of Norman and everyone who's advocates in this is committed toward fighting with a great offense and a great defense in front of the legislature to make sure we continue this fight wherever it needs to be continued. Win, lose, or draw in front of the Supreme Court, the fight will continue in the legislature. And we feel good about the way things are going to go in the legislature too. So some other questions we've kind of gotten is not only what happens in front of the Council of Bond Oversight, not only what happens in front of the legislature, is where to win, lose, or draw after this is over. Well, you know, we've got the legislative fight to do. Then there's possibly initiative petition fights beyond that. But I think the thing to take away from is we fought the good fight. We're in as good a shape as we can ever be. We're in as good a shape as anyone has ever been in front of the Supreme Court and in front of a group and in front of the courts and in front of the legislature. So the takeaway is just the Supreme Court's going to decide this soon, and we feel very good about it. We've had a fair shake on the merits. We've made our case. We think the courts are listening, and we think things are going great. And just the thing to do is just to keep up the fight and understand it's kind of my mantra. If anyone tells you these turnpikes are a done deal, you tell them, no, these turnpikes are a dead deal. There we go.
Thank you.